Welcome to Advisory Opinions. I'm Sarah Isgur. That's David French. And boy, we got a pod today. John Mulaney reads SCOTUSblog. And then we're going to switch to war crimes. Scalia turning over in his grave over legislative history. And is David so wrong about large language models and artificial intelligence? And before we dive in, David, my book is officially out on Tuesday, Last Branch Standing. And I just thought that AO listeners would enjoy knowing that on Tuesday morning, the day the book comes out, I am going on The View.
I did not know that. That's fantastic.
I have some trepidations.
Oh, it'll be great. You'll do great. Yeah. No, you do well in those settings.
If you want to tune into The View on Tuesday, April 14th, and if you've pre-ordered your book, you will have your copy in hand on Tuesday. So you can raise your copy high into the air while tuning in to The View. And I don't know, it'll be an experience one way or the other, right?
By the way, just from I envy your timing. Can I just say that? I'm green with envy over your timing because your book is coming out right after tariffs and right after the birthright citizenship argument, where the last branch standing argument is sort of maximum right now.
Yes.
Your book is landing at exactly the point where the court is agreeing with the title of your book.
If we're doing the Youngstown framework, it's at the apex of its power.
Yes, exactly.
Well, I've got The View on Tuesday, Morning Joe on Wednesday morning, and I'll be on Bill Maher on Friday, April 24th. So it's a fun lineup. I've got other book events. You can go to sarahisgur.com to see what other cities I'm going to beyond TV. But David, I think it's time to go. Well, David, just a fun few updates from our legal universe at large. One, the Supreme Court Historical Society's hometown program has opened up new cities for this summer, and they're accepting applications. Danville, Kentucky, Chattanooga, Tennessee, Portland, Maine, Minneapolis, Minnesota, Buffalo and Rochester, New York, and Louisville, Kentucky. So if you know a high school student near any of those cities, they should definitely be applying for the hometown program in their hometown.
Danville, Chattanooga, Louisville. These are three places I've spent a lot of time, Sarah. This is great. Coming into flyover country. I love it. It's fantastic.
And David, also in our extended universe, it's the thing everyone is talking about. Twitter has gone crazy talking about, it's the biggest thing for SCOTUSblog since I don't know what. This is it, right?
I know exactly what you're talking about, Sarah, and it has to be peak. This is peak stuff. John Mulaney. I don't want to steal your thunder. Go ahead, you say it.
Well, maybe we'll just roll the clip. This is John Mulaney on Stephen Colbert last week.
Listen, you're an interesting cat. A few months ago, you were spotted somewhere unexpected. Okay. A Supreme Court hearing.
I went to see them argue Learning Resources Incorporated versus Trump, otherwise known as the tariffs case.
Oh.
My good friend that I think you know, Neil Katyal.
Sure. Former Solicitor General.
Yes, former acting Solicitor General, was arguing against the tariffs in front of the Supreme Court. He invited me to go watch. We're working on a Supreme Court project together, but I'm also a Supreme Court argument nerd. This is my first live argument. I sat in the back, and it was incredible.
Wait a second.
Yes.
Okay, so let's go back one.
Sure.
You're a Supreme Court argument nerd?
Yeah.
Do you listen to them like their podcasts?
Yeah, so they're on YouTube. They're on SCOTUSblog or YouTube. You can listen to the whole 4 hours.
Just audio, right? There's no video ever.
No, they never allow cameras in there. But there are now, they have pictures, the different person talking glows, so you can follow it. And you have pretty advanced stuff.
Oh, okay.
But kind of like Grateful Dead shows, I just put on different arguments. And it's the same people every time, same clothes, but always something different.
Wow, do you have a favorite?
Favorite argument?
Favorite argument, like anything like, oh, it's one of those days. I got to listen to Santa Clara versus Southern Pacific Railroad.
Oh, that's a good one. You know that one?
Oh, yeah, 1884.
Yeah.
Yeah.
I have, there was recently one where there was a real argument, like a fight broke out.
Between the
One
person...
of the advocates accused the other side of flat out lying, and Gorsuch was like, hey, we don't say lying. And they really got into it. It got pretty hairy. And I'm sorry I don't have it, but we'll put it in the show notes.
Yes.
But my friend argued the case, and I was very excited. Neil Katyal argued and won, right? But he didn't know it that day he'd won. But he argued it brilliantly, and it was really like watching a great stand-up. It's the same principle arguing in front of the court as doing stand-up comedy. You've got 15 seconds to get him, and that's it. You have to come out of the gate really hot. You have to say, Mr. Chief Justice, and if it pleases the court, and then have like a killer sentence. And he said, tariffs are taxes, full stop, which obviously the president can't do without Congress's approval.
Yeah.
Nailed it. He walks out stage, right?
And I punch that up with
And that's what I open with every night now. But he argues this brilliantly. He walks out onto the steps of the Supreme Court on 1 Street, just like a movie, and all these cameras come up to him. And the first question was, do you know why John Mulaney was at the argument today?
David, there's almost too much to love about this. So first of all, John Mulaney, obviously a SCOTUSblog fan, and that's important, and we welcome him into the nerd tribe. No word yet on whether he listens to advisory opinions, but he and Professor Amar, who obviously is friend of the pod, are good buddies. So now that America's Constitution is part of our extended universe, we welcome you, John Mulaney, into AO Nerd World.
Oh, it's only a matter of time before you're going to notice John Mulaney in stand-up referring to buckets. He's going to gnaw dog hecklers. I mean, it is coming. There's just no question about it.
Okay, but let's actually break down some of his point here. I mean, first of all, the Grateful Dead comparison going to Supreme Court arguments. I kind of loved it, actually.
Yeah. And, when he's talking about Justice Alito and just the way, my favorite part is he's talking about the comparisons between being an oral advocate and a stand-up and coming out of the gate hot. And what's fun about it is he's obviously exaggerating for fun and for comedic effect. But like the best comedy, it all resonates with the truth. It all connects with the truth in a really interesting way. So I just thought that was a really fun moment and diversion from, I don't know, Sarah, have there been any grim events happening? I turned off my phone. I don't know what's going on.
I really appreciated the fact that he, in fact, as you say, David, like the best comedy, it exaggerates, but it comes from the truth. And you kind of got to know your subject. Mm-hmm. And so when he says, you got to come right out of the gate, Mr. Justice, and may it please the court. And then you've got to have a killer line. Like, he knew the thing you have to say before you start going. Like, he's obviously very good at noticing these things.
Yes.
And I appreciate that. There's this moment where Colbert asks him what his favorite argument is. And clearly he maybe doesn't quite know what to say to that one. And Colbert says, mine is Santa Clara County versus Southern Pacific Railroad. And I was sort of like, what?
What?
And this is an 1886 case. And it's John Marshall Harlan, majority opinion, finding for a railroad company, saying that the Equal Protection Clause of the 14th Amendment grants constitutional protections to corporations. I am dying to know why Colbert had that at his fingertips. I think he's being funny.
Yeah.
Certainly about the oral argument being his favorite, right? What is happening here?
I think that had to be just a bit because, picking out a real case. And when I saw that, I was like, wait, what? That is not, my strength is not remembering case names, which has always been kind of a struggle on the podcast because that has never been my strength. I don't think Morse v. Frederick. I think bong hits for Jesus, right? I remember the cases by their short description more than I do by their name. And so So I struggle with that a little bit anyway. I don't know why that is. It's like a mental tick that I have. And so when I was thinking, oh, I'm about to embarrass myself, I don't know off the top of my head what that case is. But it's not, I mean, that's an important case, but it's definitely not, one of the front of mind con law cases.
Nor one that you would expect Stephen Colbert to reference on the merits on anything. And I've always thought Stephen Colbert is like one of the highest IQ. I think all of these very successful comedians actually have incredibly high IQ. But even among that group, I think Stephen Colbert has sort of an overdrive factor, kind of a savant. But like that, I was like, yep, that makes sense. Of course, Stephen Colbert would cite an 1886 case.
Yeah. I mean,
impressive.
Yeah. And I can't agree more about like the high IQ. It's not just high IQ, it's extremely rapid fire recall. And the ability to remember obscure things, to call up a quip, to call up a thought, it's that their brain works at very high speed. It's just very obvious because if you've done anything, like if you have been in oral arguments, if you've been in a situation where you have to react on your feet to stuff, that's a muscle. It's a mental muscle that you have to exercise and exercise and exercise. And these guys, by the time they get to the stature of a late night host or a legendary stand-up, it's like watching LeBron at his prime, in some ways. It's pretty impressive.
Well, and to bring that back full circle, that is kind of like being an oral advocate at the Supreme Court. You're top of your game and you've got to have a lot of those same skill sets. You're using them for a different purpose, the quickness, the speed, the agility. But, maybe Mulaney's onto something.
Yeah. Yeah. No, I thought it was fantastic. I really enjoyed that.
Well, thanks for reading SCOTUSblog. We appreciated the shout out. David, I want to move to a very similar topic, which is the war in Iran. We got a question from a listener that I want to start with, which is, can the threat of a war crime be a war crime?
Right. I thought that was a really good question because in normal criminal law, the threat to commit a crime is a crime, your money or your life. That is, you're threatening somebody. The threat itself is the crime, right? So a person who hands over money in response to a threat of violence, the threat itself, even if the money is not handed over, the threat itself is the crime. Is there a comparable concept in international law of armed conflict? And I would say, in theory, yes. In practice, much tougher to say that because, when you're looking at war crimes prosecutions, it's a relatively recent question. So, I mean, it's a question I just got yesterday. So I haven't had a chance to really dive in and research the answer to it. So this is a conceptual answer. And then based on what I know about successful and completed war crimes prosecutions, I can't recall, and I know that there will be listeners who, if I can't recall it and it exists, they will be able to recall it, where you had a war crimes prosecution based purely and only on a threat of a war crime versus, say, Putin, for example, threatens all manner of things all the time. He rattles the nuclear saber, for example. But if you're looking at really the foundation of the war crimes indictment against him, it's based on the actual attacks, the actual removal of children from Ukraine, the actual attacks on Ukrainian infrastructure, the actual invasion itself. And so it's very difficult to achieve a war crimes prosecution, and they're just almost always going to be based on the completed act. However, there was a really interesting interview in PBS where a retired judge advocate said, look, there is an independent war crime of sowing terror in a civilian population. In other words, trying to sow public panic and terror. And it's arguable that a threat to end a civilization, just all by itself, could sow that kind of terror in a civilian population. But I think the bottom line reality is the way to describe it is conceptually, yes, conceptually, a threat of a crime can be a crime in the international law of armed conflict. However, practically, No. Practically, it would be exceedingly unusual and exceedingly rare. Threats of international law violations are just common in the world. It's very common, not from American presidents, but it's very common from other world leaders. It's the actual completed war crime, so to speak, that is the one that tends to get prosecuted. But I thought it was a very perceptive question, because there were a lot of people who are sort of saying, well, if he doesn't do it, it's like no harm, no foul, that there isn't any actual attack on desalinization plants. There's no actual attack on purely civilian bridges and power plants. And we talked through last time the sort of dual use, that there are circumstances in which you can attack a power plant, but it's presumptively off limits. A bridge is presumptively off limits, but you can overcome that presumption by showing clear military use. And the military use outweighs the value of it to the military, outweighs the value of it to civilians, for example, is one part of the analysis. But I thought it was a very good question, because it really does go to that sort of defense of Trump that says, well, he didn't do it, so why were you clutching your pearls? Why were you so alarmed? There's no war crime until the bombs fall. And so I thought it was a perceptive question, a very good question. And I think when you think through it, you can see the clear harm of threatening a war crime. You can see the clear difficulty that puts the military in. But at the same time, the threat itself is going to be something that would be exceedingly difficult to prosecute. And by the way, the challenge of prosecuting an American president for war crime, I mean, that would be a world historic event if that were to happen. And it's very hard to see a path where that would happen, especially with the president having the pardon power, that he could pardon himself in theory, which would, of course, lead to an extended court battle. But, I'm not confident that the Supreme Court would rule that a president cannot pardon himself. I don't see any limitations on the pardon power that exclude the president from its scope.
And you're just talking about prosecutions here in the United States. You're not talking about the Hague or any of the international law tribunals.
It would be very difficult for me to see the Hague indicting Trump based on a threat of a war crime alone. First, we have not conceded to the Rome Statute. So the jurisdiction
Correct.
of the Hague gets very iffy. It's very iffy. Now, but if the Hague attempted to establish jurisdiction, this opens up a precedent where they're going to be indicting like Kim Jong-un every 6 months or Vladimir Putin every 6 months, because these guys rattle the nuclear saber. They promise, Iran promises like death to Israel. Well, that's a threat of a war crime, right? And so threatening a war crime is a relatively common behavior by totalitarian societies in the real world. That's common. Threatening a war crime is not common for American presidents. That is not. And so I think the shocking distinction, it was a shocking moment to see an American president. And I say war crime, Sarah, let's be really clear here. The literal words that he used, if he set them in motion, that's not just a war crime. A war crime could be something like an individual soldier executes a civilian. That's a war crime. When you're talking about destroying a civilization, that's a different category of crime. That's called a crime against humanity. And why do we know that the actions that Trump threatened could constitute a crime against humanity? Because those same actions, Vladimir Putin has attempted many of them. He has attempted a comprehensive bombing of Ukrainian infrastructure, and that has actually been the foundation of the UN claim that Putin has committed crimes against humanity and the attacks on Ukraine. So what Trump was threatening was essentially the very thing that the US has been condemning Russia for 4 years. The comprehensive attack on the civilian infrastructure to punish the civilians, to create a degree of suffering that requires the nation to yield. And that is what Vladimir Putin has been trying in Ukraine for 4 years. That's what America has been condemning for 4 years. That is a core part of the war crimes allegations against Vladimir Putin that have been issued by the UN and other international institutions. And so what he was threatening here by its literal terms, was a grave breach of international law. And I feel like the term war crime doesn't quite do it justice. It's crime against humanity, the literal words that he was using. But one last thing before we move on. Even as I was talking, I was working it through in my mind. And I would say there is one area of a threatened war crime where the punishment, at least in the United States military, would be swift and severe. And it's a threat. And that would be if, say, an officer held a gun to the head of a detainee and said, "I will kill you unless you give me the information." That is a threat. That is a crime in the same sense that if somebody's holding you up at a bank, your money or your life, that's a very immediate, understandable, threatened crime that is a crime. When I'm saying it's theoretical, when you come to this point of national leaders, we don't have examples of, say, someone rattling the saber, and from the standpoint of using the national military, and then saying the very fact that you threaten to use military force as a world leader is by itself a war crime. That is something that's not where war crimes prosecutions happen. They happen once the world leader deploys the force and uses the force. But it would be a mistake to say there would be no war crimes prosecutions with just a threat, because I am aware of prosecutions in Iraq under similar circumstances.
So this gets to a larger thing that maybe we don't need to spend a ton of time on, but I just want to touch on so that people kind of know where I'm coming from. I think I've mentioned this in the past. Similarly to when I've said domestically, antitrust law doesn't exist. It sort of vibes. It's whatever is in your heart. International law exists even less. And look, here's the punchline. At the end of the day, international law makes right. International law only exists to the extent that someone is willing to enforce that with military force. And it's an agreement among nations that they would rather, work this out in a courtroom or in a, meeting room of some kind rather than use force. But that's all that international law is. It does not exist separately from any of that. And so the ICC, the International Criminal Court, is where we try war crimes, like individuals who have been accused of war crimes. The International Court of Justice settles disputes between nations. And again, those nations are saying we would rather, mediate our dispute rather than use a military conflict. In that sense, international law exists, but also doesn't exist, if that makes sense to anyone out there. The ICC thing is really interesting to me, David, because I have stared at this for a long time, and once you see it, you can't unsee it. So the ICC has indicted 73 people for war crimes.
Mm-hmm.
Let me read you the countries who have had people investigated: the Democratic Republic of Congo, Uganda, Darfur in Sudan, the Central African Republic, Kenya, Libya, Ivory Coast, Mali, Georgia, Burundi, Bangladesh/Myanmar, Afghanistan, Palestine, the Philippines, Venezuela, and Ukraine. Of those 73 public indictments, 3 are serving sentences, 7 have finished sentences. The rest are in some other limbo world. And this, of course, makes sense, David, because no big actor, sophisticated actor, whatever you want to call it, basically no one who's on the UN Security Council with veto power is ever going to allow one of their people to be indicted/brought in to the ICC. And so instead, you see the ICC, I think all of the 10, by the way, were from African countries.
Well, the ICC has issued an arrest warrant for Putin. So they have issued an arrest warrant for Putin.
Sorry, yeah, but no one thinks anything is going to happen with that.
No, there's no police force that now is going to serve a warrant in Russia.
So the only people who are actually in any fear of quote unquote justice from the ICC are from countries that, these African countries that end up with horrible civil wars, genocides, etc. And again, not saying that's a bad thing. They are doing horrible stuff down there. But nevertheless, doesn't that strike anyone as a bit odd? Like if you're from one of those countries, you're going to the ICC, but if you're from one of these countries, there's no international law. And I guess that's my point, David. There's no international law.
Ha. Well, there is international law, even for great powers when they lose a war. Nuremberg, Japan. One of the things I'm writing a piece for the Times right now that begins with a quote by Douglas MacArthur. And this is MacArthur when he is reviewing war crimes findings against Japanese soldiers and Japanese officers and leaders, including senior leaders of the government. And so there was at Nuremberg, and it has been criticized as quote unquote victor's justice. And of course, there's an element of truth there. However, the goal of the Nuremberg tribunals, the goal of the tribunals punishing Japanese war criminals, was to create a precedent to deter anybody from doing what Vladimir Putin is doing and from doing what Donald Trump threatened to do. That was part of the intention and purpose, and the UN was created to try to reinforce that. But at the end of the day, if you are a great power, you will only be held to account if you go ahead and lose a war to the extent that Japan and Germany lost with, occupation and the opportunity to literally seize the leaders. We've seen some prosecutions of, for example, Serbian war criminals after the Balkan conflicts. They lost, and justice was imposed on them, rightfully so. But you're exactly right that this is not a situation. Interpol does not have worldwide jurisdiction to serve warrants on world leaders. How, Kim Jong-un rattles the nuclear saber, knock, knock, knock. I have a warrant here for Kim Jong-un. Wouldn't that be great? But no, that is not the way the world works. But I would also note with domestic law, it depends a lot on voluntary compliance. International law depends on it more, but domestic law depends a ton on voluntary compliance.
Can I ask you a big question, but I don't want a big answer?
Okay, I agree to your terms.
Do you think the UN has outlived its usefulness, or like whether practically or philosophically, in an era where we have, Putin invading Ukraine, America attacking Iran? Like, isn't this what the UN was supposed to mediate? It's not. So as a practical matter, are we done with the UN? And so what's left of it is sort of this shell of an organization that's putting out reports that are pretty dumb. Or, maybe the UN is at it, the nadir of its power, perhaps, but like it's still serving really important purposes, maybe purposes that we don't always see or talk about, but absolutely the UN is worth keeping and funding.
Okay. The Security Council and the UN, I'll agree to your terms. It cannot work if America goes rogue. Period. If the most powerful country in the world goes rogue, it cannot work. The international system can work. It creaks, it strains, it's leaky, but it has worked to avoid great power conflict since 1945. But since 1945, the world's greatest power, the United States, has not gone rogue. And so if you look at the 5 members of the Security Council, if Britain, France, and the United States are on the same page about maintaining international law, we have a chance to keep this thing together. Not to keep the world at perfect peace, but to keep it from destroying itself like we almost did in World War II. If the world's greatest power goes rogue, the UN does not have any ability. It has a ability to issue reports, to issue condemnations, etc. But it does not have any real tangible ability to impact world events. And so that's why, you use the term that we've often used the term the indispensable nation, describing the US and the global world order. We've sort of taken over from Great Britain in that way, with the global reach, the power to reach anywhere in the world to some degree. If we go rogue, the UN has nothing. It has nothing. But if we contribute our power and authority to the UN Charter, it has teeth.
Hey, David, before we go to Scalia in his grave rolling around having a dance party, two more quick questions on this. One, this was a question from a listener. How does a service member actually assert Article 92 issues without risking being placed in the stockade, dishonorably discharged, pension disqualification, or other adverse career consequences? And please tell us what Article 92 is in your answer.
So Article 92 is failure to obey an order or regulation. It's very short. Any person subject to this chapter who violates or fails to obey any lawful general order or regulation, having knowledge of any other lawful order issued by a member of the armed forces, which it is his duty to obey, fails to obey the order, or is derelict in his performance of his duties, shall be punished as a court-martial may direct. So this is a very common article of the Uniform Code of Military Justice that is used in a variety of ways to punish people who don't follow their commander's orders. But the key word there is lawful. So a defense to an Article 92 prosecution is that the order isn't lawful.
Well, then, David, let me actually then add in our next question, because they kind of are going to combine here in a way. The other question that we got is, and I think you've answered pieces of this before, but imagine, a very senior ranking officer, and the president's like, hey, I want to attack Iran's stuff. And they're like, sir, that's a war without going to Congress, who has the power to declare war, and that's unconstitutional.
Right.
And so I refuse to follow that order, versus a member of the service and the president. Imagine the president gives the order to, attack that civilian bridge, and that officer says, no, I will not attack that civilian bridge because that's a war crime. So add in those two hypos as you're about to answer this as well. That's unconstitutional war, that's a war crime, and I'm not going to follow either order.
Perfect. Okay, I'm so glad you set it up like that, because that's so crucial. The decision to go to war, the legal responsibility for that rests with what you would call the National Command Authority. That would be the president. We do not ask rank and file soldiers to determine whether the war itself is illegal. You don't grant rank and file soldiers, even officers, even general officers, the ability to say, well, I have determined that this war violates international law, so I'm not going to participate in it. No, once the determination to go to war has been made, the legal responsibility for that, that's why if you see a war crimes indictment following a war, they're indicting the head of state, or they're indicting the head of the defense minister. They're not indicting every general, every colonel, major. No, because it's just, you couldn't run a military if you have 2 million people in the military and they're like, well, I've Googled what is just war doctrine, and that is not, we're not in a just war, so I'm not participating. You couldn't run a military like that. So the decision to go to war, the legal responsibility rests with, the best way to put it is like the National Command Authority. Once you are in war and you have been told, shoot the people who are swimming in the water who are shipwrecked, that's when the obligation, and here's the way it says it in the Department of Defense manual, of a law of armed conflict manual, orders to perform conduct that is clearly illegal. And one of the examples for clearly illegal they use in the manual, and we've talked about this before, is shooting sailors struggling in the water. Or orders that the subordinate knows in fact are illegal. That is when you have the duty. And so what that would mean is, a lot of people were tracking on Twitter, and who knows if they actually were, but Twitter's a useless dumpster fire of real news and rumor at this point. But just presume for the sake of argument that people were tracking a fleet of B-2s and B-52s heading across the ocean. If one of those crews was given an order to bomb a piece of civilian infrastructure that they knew was not dual use, right? They knew it wasn't. It was purely civilian use. They would have an obligation to say no to that. They would. Now, the problem you have in this situation, which is very scary for our republic, Sarah, is that always before, a clearly illegal order would have been something more like, my platoon sergeant told me to threaten this Iraqi prisoner with death if he doesn't to put a gun to his head if he doesn't give us the information he wants. And you get it, you go up the chain, or you go around and you say, you ask the officer to reconsider. Respectfully, sir, I understand that's a legal violation. And if you persist, you try to go up the chain. There are processes and procedures to try to seek a reversal of an unlawful order. It's sort of an action of last resort to just sort of flatly refuse. And then but in this circumstance, what if it's the president of the freaking United States of America who's given the order? Who are you going around and over to? Who is the person that you can appeal to? Well, there isn't a person. There is an entity. It's Congress. Are B-52 crews going to be like riding their congressman on the way to a bombing raid? I mean, it's absurd. So this puts service members under maximum pressure, because they have zero really recourse. The only way to do what the law requires is to just go ahead and basically throw yourself into a court-martial. That is to just flat out refuse, to create a constitutional crisis where you actually have a member of the military refusing a presidential order and the military refusing to carry out direct presidential orders. It would be hard to describe a more grave constitutional crisis, but the law as written would require them to do this, which is why, and Sarah, I just can't say it enough, character is destiny, guys. Character is destiny. And we did not realize how much we depended on the good character, even of presidents that we may have really disliked, to keep this whole machine running. Because, I served under Bush and Obama. I voted for Bush. I definitely did not vote for Obama. But when I was serving under Obama, there was no point that I was afraid that he was going to issue me or issue the soldiers I served with an order to commit a war crime. That was the furthest thing from my mind. It was also the furthest thing from my mind with George W. Bush. That was just not something to enter my calculus. And now we have it. We have crossed the Rubicon where we had a president actually threatening crimes against humanity with the expectation that Iran would believe that our military would carry it out. Otherwise, it's not a threat, right? Otherwise, it's just hot air. It's just words. And so this is a remarkable moment, and it's occurring right after Pete Hegseth is purged without any public explanation. I believe more than a dozen leading generals, including the heads of the JAG Corps and multiple services and the head of the Chaplain Corps. And what is the role of JAGs and chaplains in the United States military? Well, there are many functions, but one of the core functions of both is we work together with chaplains to protect the integrity of the military. That is one of the core functions of the Chaplain Corps and the JAG Corps. We protect the integrity of the military. And if you purge, for unexplained reasons, the people who are in charge of that process, who are tasked with that charge, then you are creating an environment that says the real value is loyalty to the president. It is not loyalty to the Constitution, to the warrior ethos, to the soldier's creed, to the UCMJ. Again, it's just, I don't think the average person appreciates the pressure that was put on the United States military in that moment. And I would expect, Sarah, I don't know this for sure. I'm just going to say, here's something that I predict. I predict in the weeks and months and years to follow, we're going to hear stories of fierce internal resistance to the Trump order, fierce internal resistance. And what you might find is that even to the point where many of the bombing raids that were going to be unleashed last night were actually not going to be unlawful, that maybe the military have narrowed down the initial targets to legitimate targets. But I would expect that you will hear, maybe again, might be days, weeks, months, years, who knows, that the military was strongly advising Pete Hegseth and Donald Trump that what they had ordered was, what they were contemplating was out of bounds. I don't know that. I just expect to hear that.
All right, we're moving to Trump versus Barbara, the birthright citizenship case. At the oral argument, we heard a lot of quotes from the debates about the ratification of the 14th Amendment and individual senators and what they were saying and their expectations. Let me read one from Mr. Howard, Senator Howard in the Senate. This will not, this being the 14th Amendment, this will not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or are not citizens of the United States. This has long been a great desideratum in the jurisprudence and legislation of the country. David, I have never used, said, or I think read the word desideratum, but I'm guessing by the context it means question, debate, etc.
Yeah, I had to get that from context clues myself, Sarah. Maybe that's a long German word that's just perfect for the moment. But yeah, I don't know. I saw that quote pop up at one point. I think I was like, thank you, Elon Musk, for your ridiculous algorithm, because I've seen that quote 5,000 times.
Okay, but here's the thing. There were lots of debates about the 14th Amendment and about exactly what the all persons born in the United States and subject to the jurisdiction thereof would mean. And you really saw the Solicitor General's office and the people in favor of the president's birthright citizenship executive order citing to these types of quotes. This one in particular, where again, it says like, it's not going to include foreigners, aliens, or families of ambassadors, to shore up the idea that the purpose of the 14th Amendment, that the president's executive order is well in line with that. I don't really want to debate those quotes or what they mean or don't mean or whatever. I
Right.
want to debate whether we look at the legislative history or the ratification history and the sort of history of the conservative movement, always saying that legislative history was not to be trusted. And yet that was always in tension with, sometimes contradictory too, depending on how you looked at it, the whole originalism thing. Like, what else are we doing but going to the Federalist Papers and talking about what the ratifiers thought the words meant by looking at what they said they thought it meant. Okay, I want to read from Dylan Esper. He's a lawyer on Twitter. He said, so Mike Lee tweeted out that section of the debates. And Dylan Esper wrote, Scalia is turning in his grave as conservatives confuse the legislative history with the text. And he goes on to say, wow, a whole lot of conservatives simply have no idea what Scalia's position on legislative history was. And this isn't a minor matter. Scalia convinced other conservative judges on it, and his view now commands a majority on the Supreme Court. And Dylan acknowledges Scalia was a bit hypocritical on constitutional interpretation, more so with respect to the Constitution and the Bill of Rights, not later provisions. But my point is, people are telling me things like, Scalia considered it whenever the text was ambiguous, which is just false. Scalia literally spent his entire career raging against legislative history and refusing to join opinions that used it. And he persuaded numerous people, including members of the current court. So no, this was his life's project, not a gotcha. This, by the way, Dylan Esper, not like the biggest Scalia fan in the world. He's trying to point out what I think we've all, been experiencing, this idea that conservative judicial philosophy is evolving quite quickly as the two parties evolve as well and realign, not in the same direction. It's just interesting that as the parties realign, the conservative legal movement is not realigning, re-evolving too. And it's why you saw in the argument over birthright citizenship, it was really the anti-administration position to talk about, text and sort of more of the originalist type arguments. And it was the pro-administration position to talk about purpose, legislative history, legislative intent. And David, I just wondered whether we should sing a few bars about why Scalia hated legislative history and why he inspired an entire generation like us to learn to hate legislative history, right? It was the idea that you're, the drunk looking for his car keys underneath the street lamp, or as Scalia put it, walking into a cocktail party, scanning the room and finding your friends.
Yes.
And that it could be manipulated so easily. Justice Barrett mentions this in her book, that once senators started realizing that the court was looking to legislative history, all of a sudden they started fabricating legislative history.
Yeah. So let's back up a minute, Sarah. This gets to a really, really, really important point about originalism. Okay, if you're a baby originalist, if you're somebody who's just heard of the term, you're going to use a phrase that is wrong. And it's a phrase, to be completely honest, I will occasionally lapse into. It will be a phrase that when I was a baby originalist, I used, and I was wrong. And it is original intent.
Well, that was originalism 1.0, right? That was what originalists were talking about in the early 1980s. In 1985, I think you would have heard Ed Meese talk about that. It's really not until Scalia comes into his own, realizes the problem with original intent, that you get to the Scalia era originalism 2.0, original public meaning.
Yes. So in other words, intent is a psychoanalysis. You're diving in and you're saying, what did they mean, really, when they wrote those words? And that's where it gets manipulable. A senator can say, well, when I am voting for this, this is what I am voting for. And it could be a plausible reading of the words. It could be a non-plausible reading of the words, but it's an attempt to influence how the statute is interpreted in a way that is not obvious from the text.
And not what everyone agrees to vote for. They only agree to vote for the text. So if Bernie Sanders takes the floor and says, here's what I think this means, and here's why I'm agreeing to vote for it, that's not proof of the meaning of the text.
No.
The text is the proof of the meaning of the text. That's the only thing that everyone agreed to. They didn't agree to Bernie Sanders' floor speech or Ted Cruz's, for that matter.
Exactly. And so you're looking at the text, and what does it mean for original public meaning? This is where we get into the history and tradition part of textual of originalism, which is, okay, that's why they look at things like early court decisions, like legislatures who were responding to the constitutional amendment after it was passed. What they're looking at is, how did people interpret those words at the time? In other words, how they were interpreted by contemporaries, not how they were conceived by the originators. And so that's a different thing. And so that's why it is so very difficult for those who are trying to overthrow birthright citizenship, because you have this really long history of interpretation, really an unbroken history of meaning in the real world that is birthright citizenship. And they're trying to go back and take individual senators or individual politicians at the time who said different things or ambiguous things and say, no, that's the original intent. But the problem you have is the public meaning for those who are wanting to uphold the EO. The public meaning has been really clear for a really long time, as that great SCOTUSblog video demonstrates. Like that the video that we talked about a couple of weeks ago before the argument really shows the very long historical interpretation of that amendment. And you're not going to be able to overturn that by putting it one senator out of, I don't know, I can't remember off the top of my head how many senators we had voting on the 14th Amendment. It wasn't 100, but one out of, 60 senators, 70 senators does not define what the words mean. The words define what they mean. And to the extent there's ambiguity, you look at how they were interpreted in the relevant historical period, not how one senator thought about them when he was voting.
David, we got another question about Barbara. You've mentioned that the Trump administration is careful to only appeal cases they think they have the likelihood of winning. But it also seems to me that their likelihood of winning this is pretty grim. Why then do they want it heard? What do they stand to gain? David, I do think it's worth pointing out that when we're talking about the interim docket, the emergency docket, that's where we're really talking about the sort of strategic appeal question. And those decisions are largely getting made by the Solicitor General and the Solicitor General alone. Mm-hmm. When you're talking about a case like the Birthright Citizenship Executive Order, I don't think he got to make that decision by himself. And even if he did, or even if he was advising the president, there is sort of this exception for the biggins.
Yeah.
They had no choice but to appeal this one. This was an EO he did on his first day in office. So I agree it undermines our point about strategic appeals. But I do think stuff like the Alien Enemies Act, birthright citizenship, when you're talking about the merits process, you kind of got to appeal your big EOs because otherwise they're just gone. Like if you don't appeal that, it's over. That's very different than the interim docket where you're just letting the stay in place during the litigation because you don't want to lose that again and make bad law. But if it's just like, does this EO work or not? Like you've got to appeal it or else you're saying that the EO was pointless and unlawful.
Right. And I think if it's a presidential priority, and if there's anything, we often talk about Trump's ideology and worldview, and it's sort of a mistake to say that there is a coherent Trumpism, but there are elements of Trump's project that have been coherent for years and years and years, and mainly around immigration and tariffs. So there's just no way that a Trump administration was going to capitulate on tariffs or birthright citizenship at the circuit court level. That was just not going to happen. They were going to go to the Supreme Court, and we were going to see exactly what we've seen, which is giant amounts of bluster and public pressure being put on the court to try to force them to yield. We've seen just incredibly harsh rhetoric from Trump towards the judges that he himself nominated. There's an obvious public pressure campaign. And, the thing is, in the Trump mind, it's always worked with the Republican members of Congress. Is definitely going to work with these judges who are my judges. And he's learning, and I don't think it's really sunk in fully, but he's learning slowly but surely that even quote unquote Trump judges are not the same people as Republican members of Congress, and they're not subject to the same bullying. And so, I think in the sort of Trumpian mindset, you push everything as far as it can to see who will yield and who will give up. And that's going to be true in the legal system as well.
All right, David, let's talk AI. Here's a question from a listener. I was struck by David's assertion that the individuals, corporations responsible for designing AI models would be legally responsible for the results of the models. That assertion sounds strange to me because of the attenuated nature of the model's designers from the model's results. The designers of the model are designing a system that they themselves don't understand and can't predict. The humans don't build the system. The humans build the computers that program the computers, that test the computers, that result from the computers that build the system. The humans have no direct input and very little ability to guide what the computers do in building the system. The closest analogy I can give to the current LLM systems is that we have put a group of toddlers with scissors and glue in a room with every picture encyclopedia ever written. There's no telling what they will make. The adult that put them in the room maybe should be put in prison for having made a poor decision, but the toddlers have been in the room for many years now and have been slicing and dicing without sufficient knowledge of rules, laws, societal norms, or meaningful input from adult humans. It has been as close to a real-life experiment with infinite monkeys typing on infinite keyboards as it is possible to get. It is neither predictable nor reversible. The legal system was not designed for the current reality, and I am by no means certain that it is capable of rising to the challenge of understanding it with the speed necessary that it will demand. David, to quote Kanye, I'm going to let you answer, but just a sec. So for me, what's interesting about that, I guess, is like, yeah, if you just like created an LLM for your own purposes, like I take your point about it being difficult legally to hold you responsible for the product of that LLM in some way, hypothetically. But when you put it out to the public to be sold for your own benefit, like commercially, and the fact that you don't know what the product will be, like sort of ain't my problem. Like once you commercially benefited, I think all of the tort laws kick in, and it doesn't matter that you don't control the output because you created a thing and sold it, right? It doesn't really matter what you created and sold. You made a widget. The fact that the widget is computers programming computers with toddlers and scissors and monkeys on keyboards, still a widget, right?
Yes. Okay. So, all right, here's the thing. I get exactly what he's saying. I do not claim to be an AI expert. There are people who can run circles around me, but I get what you're dealing with AI is different from, say, normal software, is that it is supposed to do its own thing. In other words, we've had this news about Anthropic and its Mythos program and how it has created these like 0-day exploits. And don't ask me to explain all of this. I'm already out of my depth. But Mythos, this Anthropic project, did this quote unquote on its own. Yikes. Okay, that's scary stuff. And when I've been around top-end AI developers, they are very excited to see what their LLMs do. So in other words, they're curious. They don't know necessarily exactly at what pace and speed and all of this that you will see this model develop. But the problem is they're working within a legal environment where there is zero category for machine liability for harm. Is your LLM going to write a check to a person who was disrobed against their will by the AI in public? Is Claude writing that check? No. Anthropic is writing that check. And so what I would say to the adults who've put the toddlers in the room, I want to equate you with a legal concept called assumption of risk. Okay? You can create your toddler community, but you're responsible for everything they do. Imagine, that's why kindergarten teachers have such tight control over their toddlers.
By the way, just as someone who has a kindergartner, I am stunned. I think that the kindergarten teachers are stricter and have more control than the teachers for some of the older students, because if you let your focus lapse for a second,
oh my
those
gosh,
kids are running around like total lunatics. Yeah, she's like a drill sergeant in there.
I mean, think about the phases we've seen of Grok. Like we've seen Hitler Grok, we've seen porn Grok. All of that is on Twitter. It is on X or whatever XAI, whatever is a corporate entity. And guess what? There are human beings at the head of XAI. And if their LLM runs wild and harms human beings, they are going to be held liable for it, maybe even criminally. You might have somebody put in handcuffs for the thing that their, quote, LLM did. And so there's going to be this tension. If you're wanting to create maximum freedom for your LLM to do this and that and break through various barriers, etc., you're on the hook for it all of it. It is your responsibility. You can't walk in front of a jury and say, don't blame me, blame Claude. And in the cross-examination, who owns Claude? Me. What was your salary last year with bonus? Oh, I don't know, $250 million. How many private jets do you have? I mean, 2 or 3. And you're telling me—
what leather are on those seats? And how many leather swatches did you look at? Yeah.
How much did your watch cost, dude? And so I'm sorry, guys, you cannot be king of the universe, billionaire AI, venture capitalist, developers, etc., and then go, well, look what that did. You can't do it. You cannot. And so it's just, to me, they haven't thought this through fully.
I have another AI question. A couple weeks ago, Mr. French made a strong case for why he thinks AI companies who make tools which people can use to make morally reprehensible images with should be liable for the damages that their tools inflict. So my question is, if you change the prior sentence from AI companies to gun companies, does his argument change? Should gun companies be liable in the same way that AI companies should? If not, what's the difference? Do AI companies need to come up with catchy equivalents to the phrase, guns don't kill people, people kill people?
So a gun is not an inherently illegal thing. A nude picture of a minor is, okay? And so the creating that kind of content that is inherently unlawful. The production of an AR-15 is not inherently unlawful. An AR-15 has countless legal uses. That revenge porn, whatever image, whatever it is.
But David, that seems like the wrong analogy to plug in, right? Like the AI company created an LLM, the gun company created an AR-15. A user of the LLM told it to make that image. The user of the AR-15 shot up an elementary school. Isn't that the correct analogy?
No, the analogy would be if the user of the if a person who wanted to shoot up an elementary school asked Smith & Wesson to shoot the school, and Smith & Wesson shot up the school. That's the analogy.
Okay, I get that.
Yeah, that's the analogy.
Does it matter?
Man, these are grim. Man, these are such grim examples. Yikes. Okay, anyway.
Does it matter that Congress passed a law that gave gun manufacturers immunity from some of these questions? Like, it's not that the AI companies need a catchy equivalent to the phrase "guns don't kill people, people kill people." Maybe they need a law from Congress on immunity for when you ask the LLM to make the naked image.
Yeah, that would be the solution for an AI company, is to be given some degree of legal immunity. Which, can you imagine how unpopular that would be, Sarah? If people are like losing their minds over data centers being built, one of the interesting things about AI is, in many ways, I think you'd have to go back to the Industrial Revolution to find technologies more immediately polarizing than AI, which sort of is promising on the front end, like, hey guys, a bunch of your jobs are about to go away. Welcome to the brand new, brave new world. That doesn't make people love what you're doing, right? It doesn't get people so excited about what you're doing. And so there's I totally get it. The AI technology is mind-blowing. And when I talk about it, I fully acknowledge I don't understand all of it. I really don't. I truly don't. And it's quite plain to me that I'm not the only one who's in national politics and everything that doesn't understand it. I do understand the law, and I do understand that the conceptual vision of an AI as a quasi-independent entity isn't going to fly unless the law changes. So you've seen some efforts in that direction, such as trying to have federal moratoriums on state AI regulation. These are things where the law is trying to respond to AI, but under present legal systems, Anthropic, OpenAI, Google, Microsoft, Apple, they're absolutely going to be responsible for what their LLM does. And the amount of rope that they give their LLM is the amount of risk that they are assuming. And maybe let me just revise something in real time. I said they haven't thought this through. That's uncharitable. Perhaps they've thought this through and they're assuming the risk. They're just doing it, right? They've fully thought this through. But I will tell you, a lot of AI boosters out there, AI fans out there, I know have not thought this through. I'm not going to say that about the very smart lawyers at OpenAI and Google and all of those places. Like, I'm not going to say that about those guys. So let me issue an immediate revision and correction, Sarah.
All right, David. For next week, we got this question about why we have a Solicitor General of the United States that represents the executive branch, but we don't have anyone who represents Congress's prerogatives. Not really. And whether we need a congressional general or something or other. And I want to tackle that next week. But I also want to remind people that by the time you hear our next episode, Last Branch Standing could be in your hands. Our Tuesday episode, all of your books that have been pre-ordered should be delivered on Tuesday, April 14th. So get excited. I'm so grateful. I cannot express my gratitude to all of you that pre-ordered the book. And I hope all your book plates arrived. I've gotten lots of pictures of them. I'm sorry my signature is that of like a 13-year-old boy who's, has problems. It's funny, David, I write with my right hand, but like a lefty. So it's a My handwriting's been a total disaster. They put me in remedial handwriting in 4th grade and it didn't take. So apologies for that. But if you want to see where book tour events are, etc., it's at sarahisgur.com. If you haven't pre-ordered your book, this is your last chance to get it on the day it drops, April 14th. I will tell you, I'm terrified, a little excited, but mostly terrified, if I'm being honest.
It's scary. I mean, that's what they don't tell you when you write a book. That this is going to be one of the most scary experiences professionally and anxiety-inducing, because there's nothing you do as a writer that you pour more effort and of your heart into than a book. And it's like, I've heard people describe it, it's like my kid, a professional version of like my kid. And you're putting it out there. This is my best effort. I really tried. I put everything into this. What do you think, world? And the two ways that the world can hurt you so badly is they write reviews that don't like it, or they don't care. And even worse than that is like they don't care enough to notice it, right?
The opposite of love is not hate, it is indifference.
It's indifference. But the people are not indifferent to your book, and the love is already coming in. And so I feel like I totally understand the anxiety. I have felt it to the core of my being, but I want to reassure you that you shouldn't feel it. You've already succeeded, Sarah. So congratulations.
All right. Well, see you next week.